Good afternoon, everyone. Thank you for joining us for today's program. We will begin in just about 2 minutes. Hang tight, and we'll be right back. Welcome, and thank you for joining us for Ask Me, our educational webinar series. My name is Steve Goklowski, Vice President of Care Services. I want to thank our presenting sponsor, ALS News Today, and our accessibility and inclusivity sponsor, Shionogi, as well as our mission benefactor families and everyone who helps support our programming. Programs like this one, as well as the services we provide, are made possible through these generous donations. Now and always, we want to ensure that you know that the ALS Network offers a menu of services free of charge to people with ALS and their families. Please know that if you need a piece of equipment loaned to you, emotional support or counseling, assistance with finding home care, help understanding insurance benefits, guidance in finding an ALS specialist for care or clinical trial, or just someone with expertise to answer other questions about the disease, the ALS Network is here for you. Our committed staff, who are locally based in California and Hawaii, provide high-quality, personalized, and local services, as we also fight on the legislative advocacy front and build our growing research program. We are your local team, and we are glad to provide multi-layered support. To learn more about the ALS Network, programs, and services we provide, please visit www.alsnetwork.org for more information. Today's program will be hosted by the ALS Network's Senior Director of Planned Giving, Mike Welling. Mike has more than 36 years of experience in estate planning. Throughout his career, he has led planned giving programs for several national nonprofit organizations and is recognized for his expertise in wills, living trusts, charitable trusts, retirement assets, and other tax-wise charitable giving strategies. Mike enjoys helping individuals and families of all generations navigate estate planning in a practical, approachable way, building trusted relationships that help donors achieve both their family and philanthropic goals. I will now pass it over to Mike, who will introduce our special guest speaker. Take it away, Mike.
Well, good afternoon, everyone. It's great to have all of you on this webinar today. And if some of you may or may not know that August is National Make a Will Month, which is why we are hosting this webinar on more than just wills, but on estate planning as a whole. And this is sort of a humorous way of talking about what estate planning is. Um, I can't advance my slide, but humor aside, um, estate planning is basically maintaining control or taking control of your assets, providing for the people and organizations you care about, and making your wishes clear, what you want to have happen to your assets and to other uh, family members that you care about, maybe with special needs and things of that nature, what you want to have happen and making your wishes clear, and obviously leaving a legacy with your family and friends and organizations you support. So, as Steve mentioned, my role is helping mostly the ALS community and those supporters of the ALS network, but I actually help anyone that needs assistance. And my job is to get people in a situation to get them ready to go see someone like our guest speaker today. Jacey Hayes is a fabulous attorney. I've really enjoyed getting to know her of late, and she is a graduate of UCLA. She got her JD from UC Berkeley. She has a unique circumstance of being a golden bear and a Bruin bear. So that's kind of unique. She is an estate planning and trust administration attorney in Southern California with over 20 years of experience. She's worked with some of the high-powered firms and individuals in the financial that deal with large estates and dealing with financial issues as well as estate planning issues. But she recently set up her own boutique practice to help out those that may not be of as great a means as those with lots of money and complex assets. But she helps people plan for incapacity, estate planning, wealth transfer, and charitable giving. She founded her own law firm in 2021 and is a great, she has such a great approach to estate planning, and she cares for the individual. It's not about just getting a will done or a trust done. It's about getting a will done or a trust done or both that meets the individual's needs and the family needs, and providing clarity and strategic direction for taking care of your loved ones and assets when you're gone. I just love her approach, and I've enjoyed making her acquaintance of late. And I'm going to turn this over to JC, but we have tried to address all the questions that were submitted during the registration process for the webinar. So hopefully all the questions will be answered during her presentation. If you do have questions during the program, use the Q&A function on your screen to type in a question if you didn't get it answered, and then we'll have a little bit of short Q&A after her presentation. But now I will stop sharing and turn it over to JC to take us down this road and educate us about estate planning. JC?
Hello, everyone. Thank you, Mike, for that introduction. And I am definitely grateful to be here today. I know that this is not a topic that people like to talk about. Nobody really likes talking about death, incapacity, illness, money, or basically when life just does not go according to plan. And I understand why people put their estate planning off because it's not a fun topic to talk about on a Thursday evening. But in doing this for over 20 years, I really have realized that it's not so much about all the bad stuff or the scary stuff. It's really about making sure that you have that peace of mind, that your family's going to be okay, that everything's going to be in order, that when the time comes that you can't really speak for yourself, that all of your wishes are known. And it's more about supporting, those that you love. And I think about it in terms of, you know, I have a son. He happens to be hard of hearing. And when we learned that, I dove in to find out everything that I could to make everything as, just productive and easy for him as possible. And, we put as parents, as spouses, as friends, as children, all of that attention into the people that we love. And then we leave this big thing, out of it, which is planning for when we're no longer there or we no longer can speak for ourselves. So I'm going to go through everything today. As Mike said, please, please hold your questions for the end. I will make sure that they all get, answered. And I'm trying to be as practical as possible in this. I'll hit on a few things, that have to do with more specific questions or more advanced planning, but just hit on them. My materials will be available for everyone, I believe, after or before. So, there's a good starting point for you there. But anyway, where there's a will, there's a way. And I think it's just important to understand first, and this is estate planning 101, how do assets transfer at death? First of all, know that planning is state specific. There are a lot of general, ideas and things are pretty similar, but there are some states that have, different rules. So if you're not in California, please do speak to a local professional. And on that note, I do know that people are always hesitant to spend, money on an estate planning attorney. And I think about this like, I'm sure you have, or I hope you have healthcare insurance. You probably have homeowners insurance. You probably have car insurance. You have life insurance. Maybe you have all these insurances for the what ifs. But this is not a what if. Whether you're ill, whether you're young, whether you're old, there will always come a time, death and taxes. And so planning for this is something that you can really do for yourself and that you should actually take seriously. So now getting into all of it, there are four ways, like I said, that assets pass at death. The first is by beneficiary designation. People are generally familiar with that for life insurance or retirement accounts, certain pay on death accounts. Beneficiary designation, you actually fill out a form and you designate who you want to receive that asset. That beneficiary designation trumps everything. So that's why I put it at the top. The second is what's known as operation of law, and that's when you hold an asset in joint tenancy. So in joint tenancy, it passes to the surviving tenant automatically at death, operation of law. And in California, we have community property with right of survivorship. And on that, I want to note that community property doesn't automatically transfer to your spouse. It actually has to have that language with right of survivorship to say that it transfers. I put a little bit of a broken line through there because it's not my favorite way to transfer assets. One, because you don't know who's always going to pass away first, or even if you do, then the survivor now has an asset that could potentially be, subject to probate, and we want to avoid that. So the first two ways, beneficiary designation, then operation of law, then a trust. When you create a trust, you are known as either the trustor, the grantor, the settlor. All of those terms are interchangeable. Basically, you're creating it. The trust is what's known as revocable, meaning that you can change it as long as you have capacity and are alive. And the trust is you for all purposes. It uses your social security number, and there is no different tax treatment to holding your assets while you're alive and well in a trust or outside of a trust. They're also in revocable trusts, no additional like creditor protections or things like that. You need different types of trust for that. So anyway, the first three ways, beneficiary designation, operation of law, trust. If your assets don't pass under those first three prongs, then you are in probate. And in California, especially, you do not want to be in probate. Why don't you want to be in probate? And my dad once told me that he had this teacher that put on the board, prior planning prevents poor performance. And performance was going down the side of the board. And he always remembered that. And for me, it's the same thing. Proper planning prevents probate. What does probate do? Probate transfers your assets when they're not transferred through those first three prongs. Why do you want to avoid it? One, it requires court involvement. Especially in California, the courts are backlogged, which makes it a very slow process. Two, it's public. Everything that's filed is public. All of your information becomes public. Let's say you have a partnership or you have an LLC with other members or other partners, that becomes public for them as well. Three, there's creditor claims. you have to actually send notice to all of your creditors. And there are certain creditors, like those government benefits that you receive, that can only attach to a probate estate. They can't attach to a trust. So you're opening yourself up to creditors. It is also very expensive. It starts at about 9.5% of your gross, not the net, but the gross value of the assets passing through it. And that means that there is 4% that goes right to the attorney, statutory rules, it just goes. 4% that the executor is entitled to. The probate referee who values the assets gets about 1.5%. And then there's all the court fees on top of that. Yes, that percentage decreases as the value increases, but still it is extremely costly. And again, you're having a judge who doesn't really know you or your family making the final call on everything. It takes a lot of control away from the family. So it is important to note that many states have small estate affidavits, and that's for estates that are small or don't have certain types of property that they can maybe avoid probate. At the back of the presentation, I put together a schedule of every state and what those thresholds are. I still urge you to speak to a local attorney on them, but in California, I can say definitely that if you have personal property is property that are like cars, artwork, furniture, jewelry, bank accounts, not real property. Real property is buildings, homes, anything that like sits on land. If you have personal property that's under about 208,000, you can use these small estate affidavits to collect that property. And there's a new rule as of April of 2025 that now says if your home is under 750, there's also a shortened procedure that you can use. But at the end of the day, the goal really is to have all your assets either in a trust or passing by beneficiary designation. The other thing, and I'm just giving everyone the basics right now, is there's 3 tax structures that we're always, concerned about. The first is the estate and gift tax. And if your estate is under 15 million for an individual or 30 million for an adult, for a married couple, sorry, you don't really have to worry about that. But the estate and gift tax is the amount that you can transfer either during your life or at death without paying taxes. So let's say the estate tax exemption amount is 15 million, you make a lifetime gift of 5 million, then at your death, you have 10 million left that's exempt. Anything over that 15 million mark, whether you gave it during life or at death, is subject to 40%. There's also something called a GST tax, which is to prevent the Rockefellers and Gettys of the world from transferring assets from, in trust from generation to generation without tax. But if you need more information on that, I can give that to you, later. So that's the first tax regime. It used to be much lower exemption amount. When I started working, it was 600,000 per person that could be transferred. Now with the first Trump administration and the second, it's now at that 15 million mark. But if there's ever a pendulum swing or anything like that, it could come into play. The second tax structure that is extremely, extremely important for everybody has to do with income tax. So income tax, when you pass away, everything that is in your taxable estate, everything you own, whether it's the pen that you're holding, it's, the fork you ate lunch with, whatever it is, it receives, if that's included, that's what your taxable estate is. And it receives a new income tax basis equal to the date of death value. So what does that mean? Let's say you have stock. Let's just call it Apple stock. You bought Apple stock for $100 and now it's $1,000 a share. If you were to sell that Apple stock, you would have $900 of gain and you would have to pay capital gains tax on that. If you were to hold that Apple stock and pass away owning it, then your estate, if they wanted to sell it, would not have any gain up to that, $1,000, the first 100,000, there's going to be no gain on the sale. They'll only be taxed on gain of appreciation from date of death on. So I have a lot of clients that'll come to me, oh, we really need to sell, our home to move into an assisted living or to pay for these bills or to do all these things. And there's going to be a huge tax hit. And we'll really try to work on ways to make sure that that asset can stay in that client's estate so it receives the basis step up. Now, when you pay income tax when things are sold, but your basis also comes into play for depreciation. So let's say your children inherit a house that's going to become a rental property, or they inherit a building. When you get that basis step up, you get to restart the depreciation, which is another huge income tax saving. The only assets that do not receive that income tax basis step up is the IRAs. So that's also something important to think about, that as distributions come out of the IRAs, there's still going to be income tax on that. Those are for traditional types of retirement, not for Roths. And then the third tax that, we always need to think about is property tax. And I'll have some people think, oh, I'm going to transfer part of my home to my children now, or I'm going to move my house out of my estate for, maybe to qualify for, I think, certain benefits. In California, especially, when you transfer a piece of property, that property gets reassessed for property tax purposes to fair market value unless there's an exemption. An exemption occurs if there's a transfer to a spouse. An exemption only occurs if there's a transfer between parent and child, and only now, due to Prop 19, if it's parent to child and it's the parent's personal residence, and then the child lives in it and declares it as his or her personal residence. So sometimes people think, oh, I'm being a little savvy here and moving this property out of my estate. And what they do is inadvertently trigger an income tax problem. One, because when you make a gift during life, you give your basis in the gift to the donee that you're giving it to. So that donee would lose out on the step up in basis. And two, they've transferred the property and now they trigger property tax reassessment. And all of a sudden their property taxes jump up. So you really want to be thoughtful when you're doing things as to the income tax and property tax consequences. So again, this is just the snapshot. All the information is here. Generation skipping transfer tax, kind of just going to gloss over everything. There are some states that, in addition to the federal estate tax, have a state tax. I've put a few of them here. Hawaii does too. They all have different exemptions. They all have different, rates. So it's just important to know what is particular to your state. Again, the basis step up depreciation. It's all just here for you to look back on if you have any questions. So moving on, what are the documents that you need? When a client comes to me and says, okay, I need an estate plan, what is the package that I'm going to give them? So I think the first thing is always a trust, again, because we want to avoid probate. We also, with a trust, want to create an umbrella under which all your assets can be managed. So you can actually designate your trust as the beneficiary using that beneficiary designation. You can designate the trust as the beneficiary of your life insurance, of retirement plans. We'll get into the retirement plans rules a little bit. Spouses can do rollovers, but anybody who can't, it makes sense to put it all in the trust. Unfortunately, when clients don't put everything under that one umbrella, you can have a mismatch of beneficiaries and funds. I was dealing with something recently where the house and all of the assets that had mortgage payments and insurance and everything went to one beneficiary in the trust, and all of the liquid assets went to another beneficiary outside of a trust. And now all of a sudden, there was no liquidity to pay everything that needed to be paid in the trust without selling. So it's really good to make sure that everything works together. So the first document you get is that trust, the revocable living trust, controls how assets are managed during life or at death. Now, when you have your assets in a trust and you actually have to fund your trust, what does that mean? It means taking your bucket of assets that are in your name and imagining that the trust has its own empty bucket and literally dumping the assets into that, trust bucket. You need to fund your trust. You are the trustee and you have a different capacity. Um, so then what do you need? You need also what's called a durable power of attorney. What is that? That is the ability individually to name an agent to act on your behalf for non-trust assets. What do those non-trust assets include? Well, they actually include retirement plans, which during your life have to be held in your name under the federal rules. At death, you can name a trust, but during your life, it has to be you. It's maybe your utility bills, your credit card statements, and dealing with credit card companies, dealing with medical insurance, handling taxes. That's what you need your power of attorney for. Now, your individual power of attorney does not control your trust. So if you have assets in your trust, if you're unable to serve, then the successor trustee serves. You can't just have your agent under, your power of attorney serve. It's a different capacity. There are things that you can do to work around that, like having a trustee's power of attorney. But you just kind of want to be cognizant of what's the succession plan for each, and again, have everything line up. The next document that make sure all my clients have is a healthcare directive. Every state has different healthcare directives. It does not matter what state you create your documents in, they will be respected in any state. However, it is best practice to have your documents be created in the state that you live in because, one, then the rules of the state govern, it makes it much easier to administer. Two, the banks, the doctors are more familiar with their state specific documents. And three, you don't have to worry about things essentially freezing because it's like, oh, the doctor's not familiar with this. They're going to take it to legal. So it allows things to move a little smoother when those documents are created in your state. And you are incapacitated when you move and you can't sign new documents or you haven't gotten around to it. Your original documents could still work. They're just not as easy and fluid. So your healthcare directive should be state specific so that the doctors and hospitals are very familiar with it. I generally, for my clients, like to use the actual state statutory form. Anybody can download their state's statutory form off the internet. Similarly, anyone can download the power of attorney for their state off the internet, the state, statutory form. So if funds are an issue in hiring an attorney or you need something immediately, know that those resources are available to you. Um, I don't like to put so much of my wishes, my clients' wishes, in these documents beyond what those documents ask for. I do say, though, to my clients with everything, it's so important for the people that you are naming, not only that you trust them, but that they understand what your desires are and how you want them to, execute your wishes. So prepare what's called a letter of wishes. Let them know all the details. Let them know your philosophies. Let them know your worries, your concerns. Let them know the things you're proud of. Like let them know you so that they can advocate and administer for you to the best of their ability. And then the last thing is you always need a will. Why do we have a will if the whole goal is never to be in probate? It's important to understand that a will is only used in probate. And so my goal for my clients, actually, I know this is Make a Will month and we're talking about where there's a will, there's a way. But my goal is that my clients' wills are filed with the court because in California, that's a requirement when they pass away, and that they literally stay in the basement and never see the light of day. Because that means that there was no probate, everything was being able to pass by trust or beneficiary designation, and it was all much simpler and less expensive. So now that you know that the documents that you should definitely have, and of course, if you have children, you should have a nomination of guardians. I also like to have a nomination of conservators. but that doesn't really apply, to everybody. These are the fundamental documents that you should have. Now that you know what you should have, you need to start really thinking about who is supposed to receive my assets, how are they supposed to receive my assets, what gifts do I want to make, and who do I want to put in control of each of these things. And when you're thinking about who you are naming as your trustee, and I say trustee because that's the big ticket item there, your trust. And I also say trustee because it's easier than saying trustee, agent, executor, and really all of those should line up. And similarly, everything for your healthcare should also line up, just so there's not too many, cooks in the kitchen. And again, so everything is very comprehensive. But you really should think about who you're naming. Do you trust them is the first question. It's even in the word trustee, trust. If you trust them, that's number one. Maybe they're not that financially savvy, but you trust them enough to know they'll put together a good team. Do you trust them to carry out your wishes? Trust is the first one. Then what are their skill sets? Are they good at handling, things when they're also maybe grieving or there's a lot on their plate? Do they have 5 kids of their own and they're dealing with an ill spouse themselves and maybe it's just going to be too much? Think about the personalities, the skill sets of who you're putting, in those positions, just to make sure that they don't just say yes because, of course, they want to say yes to you. They say yes because you've set things up to make it easy for them, but also they know that they can actually do the work. So think about also control how you want to express your wishes to everyone. So talking about a trust now. A trust, you create your trust. If you're married, at least in California, you'll create a trust together. In other states, each trust actually may create their own trust. I mean, each spouse may create their own trust. But in California, at least, it's easier to create one trust. That one trust can hold both separate and community property. And you have lots of options with respect to your, with your trust. Whether at the first death, everything stays in one trust for the survivor. If it does that, the survivor can do whatever they want with those assets. I have clients that love to joke about like the remarriage or finding, the new friend on the street that they're going to give everything to. When everything goes to the first spouse in this A trust structure, planners like to call that the I love you trust. It means I love you, I trust you, it's all going to you, you can do whatever you want. A disclaimer trust is a great option to also have when you're worried about maybe the tax laws might change, maybe the survivor might start to have some mental capacity issues, so that at least the spouse could disclaim and create another trust, a B trust. It's important to note, though, no matter how many subtrusts you create at the first death, the surviving spouse can still be entitled to all of the income and all of the principal from those. Mainly, when you create those subtrusts, you're doing it for tax planning and to ensure that at least a portion of the assets pass to the beneficiaries that the deceased spouse wanted it to pass to. I know this gets like a little bit, confusing and it kind of stresses people out. And so when I create my estate plans, I have with my clients what I call our design meeting. We go through everything. It's at least an hour and a half long. I want to know the stories. I want to know the personalities. I want to know the needs of everybody because I feel I can always create a plan that looks perfect on paper. But when you actually launch it into the real world with all of the different players, it could explode. So you really want that plan to be personal to you and your family. And after that design meeting, I give all my clients a chart that illustrates the plan. And then we use that chart as the roadmap going forward to make sure that all questions are answered, nothing needs to be tweaked, I have all the names spelled right. But they get to see that flow of it starting at one trust and maybe dividing into multiple trusts and then everything kind of coming back together at the end for maybe the children or something's going to charity or however it is. So I guess what I'm trying to get across here is it's so important to make sure that you understand what your plan is actually saying. And, if you don't, you can ask your attorney, hey, can you put this in a chart for me? Or can you put this in I don't know, however you can visualize it or really understand it. You want to make sure that you understand everything because this area of law is not only complicated, but if there is a word like it's nonsensical, it doesn't make common sense. It's the product of hundreds of years of like lobbyists doing different things with a internal revenue code section that's this wide. There's instances where you can create a trust where you're considered the owner for income tax purposes, but not for estate tax purposes. And there's just so many weird little things that go on. You just want to make sure that you understand it. And these are just basically your options and what the trade-offs are. And I'll let you just kind of read through that on on your own. And these are the questions that you can always come back with at the end. Um, there's two ways for beneficiaries to inherit. One, the simple way is outright. Beneficiary gets immediate control. All the assets go into the beneficiary's name. You use the beneficiary's social security number. Um, Maybe you do want it outright, but you want it outright in stages. Maybe you have younger children and you're thinking 21 is a good age, then 25 for the other third, and 30 for the next. You can really do whatever you want. These documents should be personal to you, customized. You shouldn't just probably like click on boxes and have something, spit out. But on one end of the spectrum is outright. It's simple, it's yours, minimal administration, the beneficiary controls the assets. On the other side is having that inheritance continue in trust for the beneficiary. Continuing trust does have some management, but it has three extremely important things that it does. First, it takes those assets out of the beneficiary's taxable estate. So those assets and the appreciation on those assets to a very large extent, basically up to 15 million right now, plus the appreciation would never be subject to estate tax based on the GST tax. The other thing that it does, so it puts tax planning, out of the minds of the beneficiary. The second thing it does is it preserves the separate property character of the inheritance, and that's especially important in California. And so whenever you inherit an asset in any state, it's your separate property, whether you're married or not married. In California, where we have community property and separate property, it's an even bigger deal to keep that as separate. So keeping those assets protected in that trust bubble helps those assets from being transmuted or like commingled into community property, and it helps protect your beneficiary's inheritance in the event of a divorce. So that's the second benefit. The third benefit is that unlike a trust that you create for yourself that does not have creditor protection because it's you, when you create a trust for someone else, it's like giving them their inheritance in what I like to refer to as a supercharged LLC. It has some of the greatest creditor protection. When I first started practicing, we would talk about creditor protection for people who were gamblers or who had health issues and big medical bills, people who had significant credit card debt, or maybe they had, drug and alcohol abuse issues. But now we just talk about it as if you get hit, you're in a car accident and now someone's trying to pop the limits on your insurance. Someone slips and falls in your house. At least you know that their inheritance would be protected. Now, also, if you don't think they're that great at managing their own assets, then you can name a trust for that trustee. If you also want to make sure that at their death, anything remains goes to a particular beneficiary or class of beneficiaries, you can direct that in the trust. But if you were thinking to yourself, I would have given it to my kids, let's say outright, but for hearing about Jacey talking about these trust benefits, then you can make that trust extremely flexible. How do you do that? You let the child the beneficiary be their own trustee. You give them full investment authority, full distribution authority, and you let them control who they want the assets to pass to if they remain in trust at their death. Or maybe you want all of those things, but you want to put some guardrails on who the universe of those next generation beneficiaries could be. You could say, okay, but my beneficiary has to give it to my descendants or my heirs, charities, but just not anybody else, or maybe spouses. And there's so much that you can do. So just know that that's an option. When I was practicing at my prior firm, everyone had these lifetime trusts because everybody was over the exemption, everyone was high net worth, and I got to really liking them. And I thought they shouldn't be something that's just reserved for the uber wealthy. So I would say 95% of my clients do have these long-term trusts created for their beneficiaries. As I mentioned earlier, it's important to fund your trust. If you do not fund your trust, meaning you do not take title to your assets in the name of the trust, you basically have a trust that's only as good as the paper that it's written on, because you're going to need to have a will, and the wills are always called what's pour over will, meaning there's only one beneficiary. That's the trust. But you're going to need to pour that will, those assets in a probate into the trust. I like to name the trust as the beneficiary, again, to keep everything under one umbrella. IRAs, great to first name your spouse. There's something called the Secure Act. You should just kind of be aware of it or Google it. And the new rules are that mainly inherited retirement plans have to be distributed now out within 10 years of the participants passing. But you can still put those all in the trust as long as those trusts have special provisions for it. So now let's talk about incapacity planning, because especially for ALS, families, it's not something that is just a far off thought. I know it's not secondary. It's important. When do you want your authority for the people that you're naming to step in? When do you want it to take effect? Do you want it immediately when you sign the documents? You can do that. It's called, effective immediately. You can name somebody to serve as co-trustee with you right now. You can name someone as your agent right now. Or you can have their authority begin when you become incapacitated. And you can define what that means. But I would avoid any standards that are impossible. When I started working, it was always like being signed off by two physicians. That's not easy to do. Two physicians, getting somebody who's incapacitated actually in front of two doctors who would be willing to sign each a letter of incapacity, it's not as easy as it used to be. So maybe it's a treating physician plus a family member. Maybe it's just one treating physician. Maybe it's when I can't do X, Y, and Z, this is when I want to be, determined incapacitated by a treating physician saying that I am. It's very important. It reduces friction, and it reduces things moving slower than they should when you really put in place what's the starting point for that authority. So you want to think about all of those things and not make it, too difficult. Okay. Oh, there we go. Okay, so we talked a little bit about a power of attorney when I said why it was important to have, that it was for non-trust assets. Again, you can make that immediately effective or springing. You can have your you can have your attorney, in fact, be able to make gifts. Just remember, though, that you wear two hats. Your power of attorney is for your property that's outside of the trust. Something that I think is just extremely important for people to think about, I know as we're starting to wrap up and move over to the questions and answers, is if you're going to make a charitable gift, to really make sure that you name the right charity. Make sure that the legal name is correct. For instance, just dealing with ALS Network, it's switched from the ALS Association to now ALS Network. Or I've had documents that I've been administering that just names the Big Brothers, Big Sisters, and that would go to the national office. But really, the decedent would have wanted it to go to the LA chapter. Make sure that you can actually put, the tax ID number in there and as many details as possible, the location, the city and state, to make sure that the charity that you actually want to receive your gift receives the gift. Also, think about the right asset. As I touched on briefly, the basis adjustment and income tax stuff, retirement plan benefits, if they go out to your beneficiary, they're going to have to pay income tax on it. So if you're going to make a charitable gift, using your retirement plan asset to make that gift is something super smart. Then there's also, lifetime gifts and planning too, something that I recently did for actually a family member. We talked about getting that step up in basis at death and not wanting to sell something because you would be making a huge tax, payment to Uncle Sam. You can do things like create a charitable remainder trust, move that appreciated property into the charitable remainder trust, avoid all of that capital gains tax, take money out in installments based on what the trust says. It's all very detailed. And then at your death or whenever the term of that trust ends, it goes to your charity. So in that same year you created the trust, you also get a charitable deduction. Those are things to think about when you have a highly appreciated asset that you really want to start, that you really want to make more liquid. Coordinate that, of course, with counsel. If you can't get to an attorney and you don't want to just die what's called intestate, which means subject completely to the rules of your state and how whatever the legislature thought would be best for you, you can create something called a holographic will, especially in California. I at the end of the packet of materials, I go through every 50 states and whether they allow it, whether they don't, and what the rules are. But in California, if you write your will all in your own handwriting, and I recommend that it be all in your own handwriting. The rule actually says just the material portions, but the truth is you don't want there any ever to be an issue of what's material and what's not. If you write it all in your own handwriting, you have a will. You don't need any witnesses. You should put the date and where you signed it, city and state, so that we know that it conforms to all of the rules. You want to make things very clear in it, but you can create a will. You can name who you want your executors to be. You can say that you want your executors to serve without bond. That saves money. If you trust them, then you don't want there have to be all these bond fees. You can give as much detail as possible about your assets and who they're supposed to pass to. And you also want to always have your contingency plan. What if that person's not living? Who else does it go to? Because you don't want it stuck in their probate estate. So holographic wills are what you can do. Doesn't always mean that they should be simple, but it is a way to handle things, on your own. I said I'd just lightly touch on when you need advanced planning. If your state is over 15 million as an individual or 30 million as a couple, you will need revocable life insurance trust. You should think about, if you're on the younger side, it's still insurable, gifting, grantor trusts, creating that QPERTS charitable remainder trust that I briefly touched on. So here's the other thing. Once you create your estate plan and once you create your trust, the goal is really to have it be as set it for and forget it as possible. Once you transfer your assets into the trust, they're there. Your trust should never change name. It should never change date. And you should, never take your assets out once you put them in. But, and you want your trust to be extremely thorough. Here's plan A, plan B, plan C. Try to think if you had a crystal ball to think of everything that could happen, what that trust would say. But life changes. So review your documents, marriage, divorce, death, major illness diagnosis. Look at the latest rules on exemption amounts and how that relates to the size of your estate. Recheck, who your fiduciaries are. Do you feel still comfortable with the people that you named many, many years ago? Definitely recheck your title and beneficiary designations. Make sure the asset didn't get inadvertently moved out when your house got moved out of the trust when you refinanced. Make sure your beneficiary designations not only name a primary beneficiary, but a contingent beneficiary. Because out of order deaths happen, things happen. And just make sure that your family, your fiduciaries can locate your documents. Even if it's just giving them the name of the attorney who you know has it on file, but make sure that they know how to get what they need when they need to. And always kind of keep a inventory of things if you can. When I give my plans back to my clients, it's in a binder, all organized. They'll get a USB drive with everything electronic. But then there's also a front area for them to kind of fill in important information, important assets. If you don't do that, which you should, it's not the end of the world. When I start administering an estate, usually the first thing I do is try to get the last tax returns to try to at least say, okay, I knew that there's a bank account there and but it's a lot of scrambling. The more organized that you are, the so much easier it is for the people that you love, the people that you're trusting to take care of things. So many times those people that are in charge are the ones that love you the most, and they're already dealing with grief and loss and all of these other things. Make this as easy as them, as possible. Again, it's so important to coordinate who all of your fiduciaries are. Everything financial should all line up. Everything healthcare related should all line up. Make everything as unambiguous as possible so nobody, is going, I don't really know what to do here. And just communicate. Make sure your wishes are there. Important tips. Name your trust as an additional insured on all your insurance policies, including your homeowner's insurance. Fund your trust, coordinate your plan. And if anybody ever tells you, oh, we prepared an amendment, now we need to retitle everything, that's not the case. The name and the date of your trust should never change. And if you see that you have a deed that says title is in the Hayes Family Trust as amended by the Second Amendment, it shouldn't have that language as amended by the Second Amendment, because what if you die and there's a Third Amendment now? Does that house pass under the second or the third? So whatever your trust name is, mine is Hayes Family Trust, dated November, whatever it was, that will never change. So I think I left enough time for questions. And then if you'll see at the back, I go through all of the states and the holographic wills. And I go through all the small state procedures. Again, please run this by local counsel. I did my best, but I only practice law in California. So, are we
Well,
open for questions now?
thank you so much, Jacey. And maybe I'll kick off the Q&A session. Again, at the bottom of your screen, you see a box that says Q&A. If you want to write some questions in there, please do so. But let me start this off with, I'm going to combine two questions into one, Jacey. How can I keep as much of my estate as I can, home, etc., and get Medicare and Medi-Cal? And then recommendations regarding changing names on joint bank accounts, automobiles to preserve government benefits eligibility, also advantage and strategy methods like special needs trust for the same government benefits eligibility.
Okay, so the first question basically folded Medicare and Medi-Cal into as if it's one thing. It's important to know that Medicare is health insurance, really, for people who are 65 and older. Medi-Cal is need-based coverage, and it can include long-term, healthcare. So Medicare is more on the federal side. Medi-Cal is more on the state side, and other states have their own, state-run programs. So there's certain assets that are excluded. Things are always usually changing. California changed a bunch of their limits in 2024. Then they said they're going to be bringing it back in. So you actually want to talk with somebody who is specializes in that firm, because there's also clawback periods where if you give all your assets away, there's a look back and they can bring things back in to your estate. You also really want to make sure that while you're trying to plan for Medi-Cal, you're not doing those things that I discussed earlier, where you're creating later basis issues and more taxes, or you're creating a situation where all of a sudden the property taxes on your home are going to jump up significantly because you're no longer deemed to be the owner. And so there's special lawyers out there for these types of planning, and it's extremely nuanced. And so the same thing goes with moving assets out of your estate. You have to do that within the time frame that your state requires, whether it's a 2-year look back or a 5-year look back. There are states that are much more favorable than other states. It's very, again, state specific. And so I hope that, answers, at least is helpful in starting to answer those questions.
There was another question submitted, kind of similar in nature, is if ALS spouse has dementia and the property is in a living trust, would be able to sell the property without his signature? There are successor trustees listed. We have several bank accounts and only one is in a living trust. Would we face probate for the accounts not in the living trust?
So, depending on what state you're in and if there's a small estate affidavit procedure and how much are in those accounts, decides whether or not you can or cannot, would be facing probate. What I would recommend in that situation is there's probably, if they have a trust, they probably also have a power of attorney. I would use the agent under the power of attorney to move the assets into the trust, retitle the assets into the trust, and then the trust is going to have provisions for when the person who created the trust becomes incapacitated, how to get them declared incapacitated under the terms of the trust. And then once they are declared incapacitated, the successor trustee named will step into the shoes of the person who created the trust, and they will be able to do everything that that person would have otherwise been able to do. Sell the property, reinvest the proceeds, whatever. So get everything into the trust so that you're not even worried about probate, using the power of attorney, and then go to the successor trustee to start taking control of the assets that are in the trust and do what needs to be done with respect to those assets.
Right. Another question, are there pro bono attorney resources available to low-income family members who lost a loved one to ALS recently, specifically wills and estates in North Carolina?
That I'm not very, familiar with. That would be more of a question for the ALS network, but I am sure there are, because I'm part of a network of attorneys that help low income for various other reasons, or any reason. So there are people out there that are more than willing to help. But also remember that most of the states have their statutory forms. And so you should be able to do a lot of things yourself, whether that's a statutory power of attorney, whether that's a statutory healthcare directive, if it is a small estate affidavits. You can really use, Google and the state services to get everything started.
Well, I think we're running close to time, so I'm going to wrap us up here, share my screen one last time, and say that hopefully everybody can see this. We have some resources available. Thank you, JC, so much for your presentation. JC's presentation we can send to you if you would like a copy, or a copy of our estate planning guide that we offer through the ALS network. JC talked about creative giving strategies. We also have some information on that. If you would like, just send an email to me, mwelling@alsnetwork.org, and indicate if you would like a printed or an electronic version of the guides. And I think we can offer the same with JC's presentation if she's okay with that.
Of course.
And we'll get that to you. One of the most important things that we want to get across is that, if you don't plan your estate, the state where you live has a plan for you. And it's always better to use your own than the state's, and having things go through probate and all the courts like this. And so I love this Pablo Picasso quote: so only put off until tomorrow what you're willing to die having left undone. I've experienced a last minute estate being created with somebody that I was working with for almost 2 years at the ALS network. And it's not fun helping somebody wait till the last minute. And unfortunately, she passed away about 2 weeks after she and I spoke about her plan. But we were able to get her wishes set up in regarding her family and the ALS network. So it worked out, but cutting it close like that is not something we want to do. So hopefully this seminar and this webinar and Jacey's information and the information we can provide you will help you put together a good estate plan and prevent any bad air days for you. And we thank you for being with us today. And I will turn this back over to Steve, I believe.
Great. Thank you, Mike and Jacey, for that wonderful presentation. And thank you, everyone else, for joining us today. We are grateful to each of you for being a part of our community. Once again, a big thanks to all of our sponsors for their support. If you have other questions that were not answered, including questions about the services offered at the ALS Network, please email us, askme@alsnetwork.org. The ALS Network brings our community together in various ways throughout the year to help create help and hope for families impacted by ALS today and for those who will be diagnosed in the future. These celebratory and meaningful gatherings provide opportunities for connection, and they raise awareness and funds to benefit ALS Network's mission priorities. Please visit events.alsnetwork.org to learn how you can join us. As you know, philanthropy fuels everything we do, and we are grateful to the generous donors who make gifts of all sizes throughout the year, including contributions through an estate plan. To learn more about how you can support valuable programs like this one, please visit our website at give.alsnetwork.org. And please watch for the short survey on today's presentation that you'll receive via email in order to help us plan for future programming. Thank you again, and we will see you next time.